I'm sure first of all, welcome everyone. I apologize for not being able to join earlier, but it was the hacking prevented me from joining. I wasn't part of this discussion right now, so I really don't know. There's a lot of interesting feedback and comments must have already been mentioned. So I can quickly try to summarize what I've been asked. For me, actually, as a lawyer, you can justify or categorize anything as whether it's an IAC or an IAC or whether it's not even reached that threshold. But I think, as someone, this is a political issue and it involves people, not just territory. We need to posit the right positions which benefit the people of Kashmir. And I think from that perspective, the legal body that promotes the most amount of rights would be the one we should be arguing, and that would be an IAC, which is an international armed conflict. Now, whether it for others it might be an IAC. Naturally, if you're an Indian and you have a particular position, you would say it's not even that, hasn't reached that threshold, or it's a local terrorism-based movement. But I think as lawyers, we know that. My argument would be that first of all, this NIAC and NIAC, for instance, has a definition which is different based on where you're coming from. If you are going to be using the additional protocol 2 of the Geneva Conventions, then it has a more limited categorization, and limited in the sense that if it's not that, then it would be lower than that, right? But if you're looking at customary law, it's a more broader categorization, as in a lot of conflicts which don't reach the threshold would be classified as the NIAC. For instance, if non-states are fighting between themselves, when there's no state involvement, it should still be a NIAC under customary law. Now, from our perspective, these are moot points, because I see Kashmir as an occupation. There's a self-determination that was recognized at all forums, including at the UN. India moved it under Chapter 6, and so that's clearly established, and it was like a independent territory with the ability to join one state or the other, and in my view, even be completely independent by itself. And so, by taking away that right by Indians coming in, they are basically occupying a territory. And when you are occupying a territory, and it's not, because under international law, through occupation, you cannot make any territory your own, then it is not a national, an internal issue, like a non-international conflict. It's an international conflict between the Kashmiris and the Indians, and with Kashmiris being occupied, and also with Pakistan's involvement in this. And international law doesn't just look at what a state says, but what a state actually does. Pakistan, we like it or not, has been involved in the Kashmir dispute, and this was a conflict which was at times even the Indians sort of promoted that by recently openly saying that they targeted territories in the KPK, in Balakot. That makes this into an international armed conflict. The sustainability of that conflict is something we can question, but I think with the amount of, if you look at the Tajik case, which is now considered to be customary law, the threshold of conflict and the organization of Kashmiris is greater than that was in that case. So you fulfill the requirements of the intensity of a conflict. The question then is whether it's non-international or it's international. For me, as I said, while others argue that a lot of AP1 is now part of customary international law, it shouldn't matter. It should. Humans are humans, combatants and civilians are all the same, whether they are in an international or in a non-international armed conflict. So, from my perspective, it is an international armed conflict, and Pakistan should surely say that, rather than getting into this debate of whether it's a non-international armed conflict or it's not one. Having said that, common Article 3 applies in Kashmir because it's something that is what is being built on an AP2. Pellet guns, recent flare-up in violence is reflective of India committing acts of war crimes. I'm not saying that we shouldn't argue international human rights law. The right of self-determination also. There are two ways in which you can capture it. It's external and internal, and for Kashmiris it's external because it's not like they've been deprived of socio-economic rights from within India as Indian citizens. But I think what needs to be focused on is the IHL part of things like the just in below vis-a-vis violations of international humanitarian law when it comes to Kashmiris, and that needs to be outlined. As we know, there are customary requirements of proportionality, military necessity, unnecessary suffering, and using weapons that are means and methods of warfare. So using pellet guns is not legal. Military necessity of taking certain actions in civilian territories and targeting civilians directly is both a violation of AP1 and also AP2. You can't make civilians the object of primarily the object of an attack, and the collateral needs to be measured in light of the objectives that are to be achieved by India indulging in a belligerent occupation. Now, also, I think that the status of combatants and civilians need to be clearly outlined in the case of Kashmir. I wrote an op-ed in Dawn News where I talked about Burhan Wani as a Kashmiri combatant, as a fighter, and even Dawn was scared because they felt that the state of Pakistan, because it has classified Hizbul Mujahideen as a terrorist organization, somehow affects our designation of people as combatants. And my response to them was that under IHL law there is no terrorism. There is only war crimes, and so there's also status and actions. So the state parties and the actions of parties have to be kept separate. If someone indulges in an act of terrorism, it could very well be a war crime, but the classification of a whole group based on certain actions is not the domain of IHL law. It is the domain of maybe domestic law or international human rights law or UN law. So I think that we need to be clear that in Kashmir you have two categories of people. Either you have combatants or civilians. As combatants who are fighting occupation, they are privileged. They have access to certain rights because they can be targeted, which would mean all the sort of immunities that come with combatant status. Which is, you can target a combatant if he's actively engaged in hostilities, and also keeping in mind the mechanisms of war, the engagement of, or the, how do I say this, the act of conducting warfare or armed conflict in Kashmir by the Kashmiris need to be measured under IHL standards and their own sort of military capabilities. So naturally, when a person takes truck as a platform with weapons, with sort of grenades or whatnot, explosives, and targets an Indian sort of a military like with vehicles, or what do you call it, like a group of, and this happened previously, so consignment or whatever, and that would be legal under IHL law because there's no direct targeting of civilians. You are limited by your own weaponry. You don't have F-16s or MiGs or whatever to target people in a sort of combatants in a strategic way. You will use what you have, and that's the standard you'd be measured by, and that would be a lawful use of force. And also you would be subject to all those immunities, like you can't be targeted if you are in your homes, if you're not engaged in conflict directly at that point in time, which is what recently, my understanding is what happened when a few houses, Riyaz Naiku, I think, there was, my understanding is that is, there were civilians in civilian localities, there was, targeting of civilians, with combatants in who perhaps, well, arguably they could be targeted if they were given that status, but not as, if they've surrendered, then they can't be targeted. So those are things that, you can't just execute extrajudicially people if they're combatants, and you can't punish them for being combatants. And likewise, coming to civilians can only be targeted if they're what are called DPH, directly participating in hostilities. And if civilians are targeted when they are not directly participating in hostilities, which is what is happening in Kashmir, then the armed forces of India are committing war crimes. So I think the narrative should move from human rights and domestic law, because invariably national security comes in and you talk about terrorism regimes, and we need to focus on an IHL sort of. And for that, I think what is important in Pakistan is, and I'm going to sort of end here, is that we need to prove our understanding of IHL law. we have an expert here, Justice Ali Nawaz Chauhan, who served on ICTY, and probably he is the only person in our judiciary. I mean, maybe there are others who focused on this at that level and understand international criminal law and IHL law. Otherwise, unfortunately, at least at the high court level, judges in Pakistan don't understand this framework. And actually, the narrative also doesn't come into the media. People have no understanding of what IHL law is. They talk about human rights and self-determination, and maybe just add bellum, the right of self-determination at some level. But there needs to be a deeper understanding of these crimes, war crimes, crimes against humanity, genocide, and the legal frameworks that can be employed. Whether if we can't do them, maybe other countries can. I mean, recently there was a case, as you know, where for ICC jurisdiction, you need to have acts committed on your own territory for it to be, and you have to have signed the convention. So arguably, if let's say Azad Jammu and Kashmir or Pakistan or someone is, I mean, if we go ahead and we sign the convention, then we can argue that India is committing war crimes on, I mean, of course, that comes with a grain of salt because you also are going through certain upheavals within this country. But I mean, there are other ways in which you can approach other countries who might be able to go to the ICJ, let's say, for instance, using the general jurisdiction of the ICJ. Where India has put in a declaration, but basically, they wouldn't be bound by the Commonwealth exception, and that declaration can always be negotiated in court or argued in court at the preliminary injunction stage, because Kashmir is a case that has gone to the UN. So while we can't take the case, while there might not be a treaty on the basis of which we can argue compromissory jurisdiction, general jurisdiction could be used, like the Marshall Islands uses against Pakistan and India. On nuclear weapons. So I think what needs to be done is that the state of Pakistan has to be serious about this. We need to engage with Kashmir's diaspora and Kashmiri leaders to come up with ways in which we can pressure India both politically and legally at international forums. And even if we don't win a case, that pressure would be enough, like in the Yadav case, to force India to change its tactics. Now, I will stop there. Thank you.